19 of today's list, my lord, I am for the appellant. I am playing not today.
19, make a note, not today. Yes.
On application in connection with the appeal, at the section 5 application stage, or the interim order was passed. I am appearing, my lord, for the writ petitioner respondent. Since I am suffering from interim order, your lordship kindly may included in the list.
You have prayed for vacating the interim order.
So the affidavit direction was there, affidavit file. Thereafter, no hearing.
It is their appeal, they have to mention. You cannot mention.
Suffering interim order.
So if you file a stay vacating petition, then only you can mention your application. If you file an application for vacating the interim order. Otherwise, it is for the appellant to take up his case. Yes.
An application in connection with the appeal. Application in connection with the appeal.
Give it next week, any day.
Next one.
Pending, and ST application is also pending against the, and contempt has been filed, your lordship. So your lordship kindly.
So filing of contempt means what? Let it be filed. Unless there is some precipitatory action, why we should stay?
Kindly appeal be appeared to be mentioned here.
No. Unless some order is being passed, there is something going to happen in the contempt. Merely filing of contempt does not mean it has to be stayed. We don't know. If there is something like that, you can come. Yes.
At least application be.
It will come in the next monthly list, include in the next monthly list.
Your lordship may be allowed to mention one matter for inclusion in the daily list.
Hmm?
Two matter, your lordship.
Inclusion, please give the inclusion. All right. Anyway, this for the state is here.
Item number 1.
Who is for the state? See, they have pointed out actually there is an error, inadvertent error. On 20th, taken up. On that day, because of that, some police action, you had abstained from work on 20 November. On that day, a prayer was made that it should come on 9th December to enable the learned Advocate General to appear. But due to inadvertence, they placed it the next day. Next day, it was extensively argued. So that mistake is now of no consequence. We are just going to clarify that. Take down. Please, you must learn these things. This is not the way. We have patiently heard you, everything you submitted. This can't be an endless exercise. Yes.
Item number 2.
Matter,
The heading for orders.
the last occasion, taking the practice errors now, in respect of the examination.
But one copy may be
qualified and not qualified. You have given
A copy may of this
copy of the not working out. Copy of the result. being handed over.
Here on behalf of the petitioner, this is the matter with regard to grant of compassionate appointment. Point involved was as to whether the claim for compassionate appointment can be rejected on the ground of the fact that the date occurred at a point of time when the claimant was excess in age. Now, Miller, certain circulars excess in age. Miller, this is a very, I say, Miller, with the greatest of my respect, I did not find it, but I had made a frantic efforts on my part, Miller, to ascertain as to what are the relevant circulars prevailing in the field. But however, Miller, it seems, Miller, that there were two directions for filing of affidavits.
Your Lordship,
And-
affidavit have been filed, Your Lordship. A copy has been, we have been trying to serve a physical copy. We have failed. We have WhatsApp the PDF. We are giving the.
Normally, I am in the court Miller every
It should
day.
be
I am
it
not.
has been-
Serve on you. They will
Yes,
serve
yes.
the
That's all.
advocate only.
affidavit in opposition is being served.
Miller, only one indulgence.
Yes.
I can file the reply within 7 days. 10 days. I say, Miller, there's an abundant caution. I take it at 10 days. I leave it to the court. I leave it to the court, but only kindly retain the position. Miller, I will not be taking more than Miller 15 minutes time of my lords. Because
Affidavit in opposition is being filed after due service upon the applicant for the late petitioner. Stop.
You know,
an application filed before the tribunal and before it. Second their copy may be given after.
What is it?
With the tribunal,
What are you handing over?
evidently it has it. One
Why one copy? We will not accept one copy.
generally we have the one copy.
No, no, the division bench always did 2 copies.
I filed an application before the tribunal And at this stage, there is no presiding officer in the tribunal. On 6th, 11th, the date was fixed.
Very
We
good.
admit the appeal. Opposition was given. The state was not given any opposition. There is no state. One of the petitioner before appointed as a constable, and kindly see the page.
He's not for you.
It must be named. 14 meter.
You have preferred any appeal against the superintendent's order?
My lord, appeal is tribunal, before the tribunal.
An appeal lies against the superintendent's order before the tribunal?
No, tribunal. No appeal was made. Before the tribunal,
Why you did not prefer an appeal? Is there no provision of appeal? Is the superintendent's order appealable?
Manad, he was discharged when he was undergoing a training on medical ground.
Whatever it is, if there is, so he was still on probation.
Yes. Manad,
That is an order passed under which provision?
each and every employee of the government, if he has selected, then undergoing a training, then he will be placed if sub
Page 57, the order of the discharge by the superintendent of police.
What we want to know is, in central service, there is a temporary service rules.
yes.
Under section 5 of the temporary service
Mhm.
rules, an order of dismissal or discharge can be passed against a probationer.
Maybe, yeah. Now, while he was undergoing training,
Such provision in the state service,
he was undergoing a training
correct? So
Correct.
after appointment,
after appointment, but
yes,
before selection, after completion of training, he will be posted in any
training is always after appointment.
appointment.
So that order is passed under which provision, that we are asking. Where is the order? Where is the order?
Page 30, page 57, worship inner
57.
page 57.
57. K9.
First of May 2023.
First May 20.
Electricity.
Appointed as constable to West Bengal Police.
No departmental proceeding is necessary.
Not the point. The point is, there is a review medical board.
Medical board.
That board has found him to be suffering with some amblyopia.
Yeah.
Now, if he wants to challenge the finding of the board or the order of the superintendent, which authority he will approach, or he is remedialist, that is what we are trying to assert. Therefore, we are saying it is passed under which provision? We understand that proceeding may not be required,
A department proceeding is not
may
necessary.
not be required, but is the order appealable? Is there any forum which he can approach? Or he is remedialess? Yeah.
After 1 year, 18th May I appointed, 18th April I appointed, and the discharge on 1st May 2025, after 1 year.
But I understand that there is appellate of this, but who will be the appellate of this? DIG of the particular day.
So why you will not approach him? Why you have gone to the tribunal unnecessarily?
On the part of the if you not give liberty.
DIG.
Yes, matter is taken.
Item number 5.
May I please your lordship? Appeared for the Lord appellant WBC TCL Electricity Company. We prefer this appeal against the order introduced in intercourt order appeal
Against?
against an order passed by this Lord normal trial court here. Intercourt appeal. It's a matter appears to be very easy, very innocuous, but inside Lord, there is a Lord, very crucial story. Petitioner who moved the petition, he posed that I have 1 meter. The meter is defective. In spite of my prayer, meter is not being replaced. That was the case he placed before the court. And on the very date, order has been passed very well. You take step and replace it. Then, Milord, we got instruction. We found the person was enjoying 4 meters. And in 4 meters, there are Milord around 12 lakhs outstanding dues. And the same person. But he has not stated anything here. But in the meantime, order has been passed. You replace it. So, Milord, we did not have any scope but to file this appeal before lordship. Now the point is, Milord, a person having 4 meters, outstanding amount is 12 lakhs. He is entitled to have any relief in respect of 1 meter or not. Whether it is correct, his allegation is correct. Our submission would be before lordship is, law is very clear on this. If a person uses number of meters in his own name and not paying anything, he will have to make payment in respect to all the meter, even if he is asking relief in respect to 1 meter.
Show the law.
And we are Milord, obliged to, Milord, this is regulation 55. Lord, you can take note 3.4.2. Regulation 55 3.4.2 and Milord, regulation
55.
55 regulation WBRC regulation 55 3.4.2.
Yes.
Where it is stated that we are entitled to recover the amount, even if subsequently any other beneficiary comes in from him also. And the person is having other meters or other premises, we are entitled to recover it also.
So who is stopping you from making
We
recovery?
shall do it, but that time it was not.
Who is stopping you? How the order is coming in the way of recovery?
He is asking for taking steps to reconnect the connections. We cannot.
He is not.
We cannot.
He is not. Please show from the order whether he has asked for reconnection.
That's the order.
Please see from the order, show us where the court has directed for reconnection.
Not reconnection.
Then why are you saying he is asking for reconnection?
Replacement, Lordship. He is saying that replacement of meter.
We are asking you what comes in the way of your making recovery because of this order.
I respectfully submit.
Now please tell us.
If I, Milord, comply that order without preferring appeal, then I will have to, Milord, without recovery, will have to replace the meter. Replace the meter means to make it running as it was.
You may understand it that way. It will be good for the petitioner if you understand it that way.
We replace the meter without.
You may understand it that way. It will be good for the petitioner. We are asking you to show from the order.
It is not there.
Then what is the big thing in that? You said there is a big thing in this matter.
One
It appears like nothing.
I tell you, Lordship.
Yes.
A person is asking that you replace my meter.
That is all. Nothing else.
Suppression.
Nothing else.
Well, suppression is the important thing.
That is not.
In a lead court, Milord,
He may have 5 meters.
He should disclose it.
If he is aggrieved by the functioning of a particular meter.
No, another story is also there. I have not completed.
Yes.
What happened, Milord? Other 3 meters were disconnected. What he did?
So how is that relevant?
From 1 meter, bypassing a meter, and he reconnected all the meters.
So you take all action. Who is stopping you from taking action? We don't know what you have done, whether you have taken action against him, you have not
We
taken.
cannot. Lordship, we are beseeching that we shall be expecting. My Lord will certainly encourage our stand that very well. Don't take any step in his favor by not replacing the meter. If we replace the meter, then his prayer is allowed and he will remain as it is.
Whether his connection is energized.
That's old, Milord, old matters.
So how are you? You have no instructions.
As on date, current instruction as on.
Why we had already adjourned it, making a very clear.
We have intimated
A clear prima facie opinion that there appears to be nothing. Then you should have come with such instructions.
My Lord, I will be, Milord. Today also, Milord, I had a talk.
Yes.
They are saying, Milord, what happened? It is in a Birbhum area, Nolhati. Lordship will kindly appreciate. 4 meters, 4 submersible pump in different.
How many times you will say 4 meters? Saying it thrice will not make it 12. We have understood he has 4 meters. The issue remains the same. 1 out of the 4 meters may not be functional. Court has directed to change.
The amount to be recovered.
Who is saying not to recover, sir?
To take any
How many times we will ask you the same question?
My lord, kindly appreciate. How can we, if we grant the relief to him,
That is for you to understand.
we'll have to.
You see, your recovery is for you to do. It's not for the court to make the recovery for you.
Only what I am beseeching, my lord, since gross suppression he is there,
Let us
he has not disclosed.
see
has not
suppression.
disclosed. It will be discussed.
Suppression is always looked down upon, and the writ court does not exercise jurisdiction if there is suppression of a relevant and material fact. Therefore, repeatedly we are asking you how it comes in the way of recovery. Unless it comes in the way of recovery, unless it is by that he is gaining some advantage, how it is a relevant and material fact? He may not disclose
May I
that there are 4 meters or 10 meters. He may be having 15 meters. There may be dues against him.
That is what I am saying, my lord.
Who is stopping you? You go and collect whatever you want to. Why the order has to be? We are only on this order. Please show us what is the infirmity in the order. The court has said that he complains he has a defective meter. Court said you make payment, the defective meter will be replaced. Whether there is electricity in that connection, whether there is no electricity, is there anything? Just read from the order.
From the order, lord, so can you see?
Please read the order.
We could have said that yes, my lord, we cannot take step recovery or whatever it is replacement because suppression is there. These are the 4 meters he is running without making payment.
See,
We didn't have an opportunity to say so.
so we are again and again asking you how the suppression is relevant and material.
Relevant in the sense, my lord.
Tell us now. Come to the order. How it is relevant?
Before that, 1 minute, lord.
Come to-
Kindly give me 1 minute time.
Yes.
My lord, if we comply the order, meter defective meter, he is saying we give a very good meter. Or if we test it, it is correct meter. According to us, if we found it is correct meter, consumer always says it is not proper, it is incorrect. If we found it is correct, or if we find it defective, then if we comply the order, we'll have to give a new meter or corrected meter.
On payment.
And you will very well know, on payment means meter cost only.
Yes.
But as regards the payment of other 4 meters for dues, we cannot say anything.
So therefore, again we are
Court will
asking.
say,
Again we are asking you, by replacing this meter, how his due in the other connections will be affected. Show us, please. How the other meters dues will be affected by
Yes.
replacing this.
yes, we cannot grant. I am
Which
telling you,
provision? Come to the
Lordship,
provision.
Lordship.
We are hearing you.
55 3.4.2 I have referred, Lordship.
50 point, you have said 3.4.2. What is
Lordship,
that
Lord-
provision?
Lordship,
Show us.
Lordship, kindly allow me 1 second, Lordship. I was not fully prepared in this matter today because I do not know it will be hard. 1 second. 55.
You did not know. He did not tell you.
No.
He did not tell you.
According to his, he informed me, my lord.
Then don't say I did not know. Please.
I'm not prepared fully.
Don't say I did not know. Don't make such submissions.
No, not.
We have
what
told
I'm
him,
saying.
we have made a prima facie
No, no, he
observation.
told me, my lord.
Yes, now you may proceed.
Lord.
Yes.
55 to query. No. My lord, and also, my lord, I want to place, my lord, regulation 46. 55, my lord, I don't find here. 55 regulation is not here, lordship.
Regulation. Which regulation? Which regulation is referring? Get that regulation.
Lordship, 3 point. Regulation 55, lordship. Yeah, someone can't tell na. Lordship, kindly excuse me. This is and Milord also 13.9. Regulation
13.9.
46, regulation 46, 13.9, and regulation 55, 3.4.2.
You said 55, 3.4.2.
Lordship, that I am placing, Lordship. Can I have a look to this? May I read it once, Milord? Subject to
55, 3.4.2.
Lordship. 3.4.2. Here, Milord, the licensee shall be eligible to recover from a new and subsequent consumers the dues of the previous and defaulting consumers in respect of same premises only if an excess between the previous and defaulting consumers and the new consumers in respect of the same premises is proved. The onus of proving an excess is claimed by licensee shall lie on him. He is enjoying 4 meters on excess millage apparent.
Then you should.
This one. We are entitled to recover. This is what I am saying. And Milord, another is Milord, regulation 46.
46.
Lordship, regulation 46, 13.9, Lordship. For getting new connection for supply of electricity and intending consumers shall be required to pay all outstanding dues to the licensee in respect of any other service connection held in his or her name located in the area of the supply of the same licensee, and he shall also be responsible for payment of outstanding dues calculated in a prorated manner if it is established that he has had an excess with the previous consumers, including the purchaser, the new licensee, the tenant, the property, and the portion thereof in regard to of which there are outstanding charges and or who has or had benefited from non-payment of the aforesaid outstanding dues by the previous consumers of the same. So, Milord, these are the two provisions relying on, Milord, what I am beseeching, Milord, we have the power to recover for all outstanding. That's the only area where. That's why, Milord, we have not, Milord, kindly, Milord. I'm sorry, Milord, I don't have the extra copies and all this. Milord, this is regulation 46, paragraph 13.9, and another I have given, Milord, 55, 3.4.2.
Yes, take that. That's all.
Milord,
Yes, take that.
Prayer, my lord, we are at liberty to proceed to recover the amount.
You
if
would
any.
have said that, but you did not. You are saying that the order is bad. We have repeatedly asked you who is coming in the.
Kindly, my lord, give that relief at least, my lord, otherwise it will prejudicially seriously, lord.
Yes, learned advocate submits that the
Obliged to lords.
এটা লাগবে একটাও দিয়েছে 13.9 13.9 item number 6
issued two tenders. He was a authority, and by those two tenders, has surfaced that certain legality or gratitude he has taken from the partner, anyone partner. Following which, there was subsequently an FIR lodged by the certificate of investigation. The matter was investigated. Now, why he was posted as the Lieutenant General? Since there has been, there has been no proceeding initiated by the appellants here. In the matter involved civilians and whom will not be tried by the civilians. Yes. You heard this matter? Yes, yes, sir. I mean, advice
Well, the Honorable Single Judge came to a conclusion that we have not initiated a disciplinary proceeding by which we are incapacitated from
some rule was required.
FR, fundamental rules. My lords were last seeing the fundamental rules. Now, my case is that the allegation was against the writ petitioner respondent that while he being posted as DIG provisional at Frontier Headquarters BSF Malda, he demanded illegal gratification for facilitating the supply of orders of tents in respect of BSF.
It has been quite some time. Please refresh.
My lord.
It has been quite some time. Please refresh. So therefore, he was the tendering authority. He was proceeded against by the CBI. Then what happened?
So his information was received and accordingly, on the basis of a complaint, FIR was drawn up. CBI is investigating. FIR drawn up on. Charge sheet has been submitted. Prosecution is ongoing.
And
now they preferred a writ petition. FIR was under section 120B IPC and read with section 7, 12. Section 13 subsection 1 clause D, section 13 subsection 2 of Prevention of Corruption Act, PC Act. There was a search on 14 June, 11 June was the FIR drawn up, 14 June there was a search, some materials were recovered, seizure list is also annexed with the petition. Thereafter, on 9th September 2013, we suspended him under Section 40A. Section 2, Rule 40A. Rule 40A of the BS Border Security Force Rules of 1969. On 8th January 2016, charge sheet was submitted.
When was he suspended?
9th September 2013. Under Rule 40A.
Yes.
If my lord kindly comes to, I will place, but at a cursory look, may I place it? Paragraph, page 6, paragraph D of my stay petition states the various period by which his suspension was extended from time to time. Those were done on the basis of internal reports of the Government of India, Ministry of Home Affairs. Now, on 8th January 2016, yeah, okay. Okay.
Why the Bombay Civil Service rules were being considered?
Yes, some judgments were relied on where Bombay Civil Service rules was considered. That has been repealed in 1983 by the Maharashtra Civil Service rules. That judgment on the basis of repealed act was relied on at the time of hearing. And the impugned judgment was passed. Now, my lord, on 22nd February 2019, the suspension was revoked with effect from 22nd February 2019. This suspension was revoked with effect from 10th February 2019. And the respondent retired on, writ petitioner respondent retired on 30th April 2019. Thereafter, the prior thereto, the writ was preferred and it was.
Prior to his retirement.
My lord?
Prior to his retirement.
Yes, yes. And the writ petition was disposed of on 14 November 2019, directing him to pay all the back wages. Now, page 58 to 69 is the search and seizure list of the stay petition. Sufficient materials were gathered by CBI. Since prosecution is pending, I am not going into the niceties of the entire materials because this is, with deepest of respect, this is not the proper forum to appraise the entire, appraising the entire materials, what has been found. The learned magistrate is already in season. 58 to 69 are all the seizure lists.
What the relief was being sought by the petitioner in the proceeding?
He prayed for granting him the back wages, treating the suspension to be bad. Page 53 of the stay petition. Actually, order of suspension was set aside with effect from 2013, and and we were directed to pay all the back wages. Thank you.
The writ was filed when? 2018.
It was filed in. It has been affirmed on in 2018.
So the private respondent is appearing in this.
We have notified him. Repeatedly, we have notified him. Lastly, I have served him a notice. May I be permitted to hand over?
Is he still representing them?
No, not representing because.
Oh, he is not representing. He has made an endorsement saying that in spite of request, repeated try to reach to client, neither he contacted nor respondent to our letters. Accordingly, we are not appearing in the matter any further. We can send notice to the respondents.
Otherwise, how can we proceed?
This is the probably this is the fifth time the matter is before your lordship.
What can be done? The absence, how can we? He is the advocate on record. This gentleman who has signed this.
Yes, yes, he is the advocate on record. At least as far my knowledge goes, till the date of letter, issuance of this letter, he was the advocate on record. Right now, I do not know presently, but it was copy service.
This is of September.
September. Yes, that time he was advocate on record. In fact, there was an order of your lordship to serve upon him. 11th September, there was an order of your lordships, and we served him on 12th of September. Include order to page
Serve a
number.
notice on the party. What can be done? Serve a notice on the respondent. Pursuant to the last order of the
Returnable.
17th.
I'm grateful to you, Lord.
17th December.
Item number 7.
Please, Lordship. I am from the applicant. I am only please.
all right, not today. Will come on which day you tell him? Third December. How long you were researching?
Item number 8.
But I went to this CSC, my lord.
Your father responded.
My lord, CSC, but my lord, till date I have not received the copy of the appeal or neither the memo nor the stay, nothing, my lord.
What is CESC?
Calcutta Electric Supply.
Electric supply.
My lord.
There is none to represent appellant.
They give a direction to serve copy upon the response. To whom?
Third December.
Third December.
You don't know whether he will choose to appear or not.
That's true. Grateful.
Will your lordship be kind enough to give us leave to at least go through the record?
Yes, you can see.
Item number 9.
Lordship, I'm led by Mr. Achyut Basu. This is a very old matter and we are not in connection with the client for a long time. So we need to take some necessary action.
কালকে বাড়ি যাচ্ছি উদয়পুর করে
I'm seeking for 2 weeks again.
Yes. Yeah.
Item number 10. ডিসেম্বরে আসছে করে আসছে
None appear.
Item number 11.
And for the appellant petitioner, matter is appearing after a long time. It has never been heard. The receipt were-
It's a long time.
it is after COVID, filed during the COVID period.
Only 10 people. Only.
We have also lost the brief.
What is the issue? You are for?
I'm for the appellant petitioner.
You are the writ petitioner.
I'm the writ petitioner.
What do you want?
Subject to your lordship kind consideration, this is not a hearing matter. The pleadings has not been extended. Lordship has the jurisdiction of hearing only. It is a residuary appeal and it's in admission stage. We have also not filed any application and we also lost the brief also. I need the copy of the brief. Your lordship kindly permit to send back the file to the department so that I can apply for certified copy
Certified copy of?
this memorandum of appeal.
You don't have a copy?
We have lost during the COVID period.
Date day 24th. পরের বছর রাজবেলা তুমি কি স্টাফ জানুয়ারির 6 তারিখ
Item number 12.
Not working.
We can give it.
Item number 13.
None appears. Same order.
Item number 14.
Yes, same order.
Item number 15.
I'm appealing for the
Hmm? Hmm. Why it has been listed? Why it is the disposal matter? Why it is listed? 9/9/24 it was dismissed, disposed of. Why it is listed?
অ্যাপ্লিকেশন কেন করেছে
Can one stay?
ও স্টে ওর সঙ্গে ডিসমিস অল ডিসমিসড
It is already dismissed. Then why again order has to be placed? Matter appears to have been wrongly.
already
16,
It appear for the appellant bank.
Hackler.
Where is the circular of 15/9/2010?
It's at page 42. I have prepared a short list of dates for your lordships. Can
Yes. Whether that option was available to retired employees also? Then
There
what?
was a specified time by, not, it appears that the gentleman had applied before the circular had been enforced, number one. Number two, there was a time period by which he had to refund with interest the employer's share of PF contributions, which was 60 days from the date of option. Now, this all followed from a joint bipartite note of settlement for the officers on all over the country as a last chance for exercise of option. Now, this created not some suspicion, but of course not because of the merger of bank and the long lapse of time. We were unable to trace records, and in fact, the original pension application was not found. Option form was not found available in the bank's trunks, which had now been sent to South India for the purpose of because of the merger. Now, two dates may be very necessary for your lordship's kind consideration. But the case run by the writ petitioner was that he had submitted the option form to the bank on 6th of September 2010. Now, 13th September 2010 is the date on which the branch received the option form.
He has a receiving also.
Yes, he has a receiving also. Then 15th September 2010 is the circular issued by the bank for fresh pension option. So, the branches received the option forms and then the bank issued the circular. As a preparatory measure, these were sent to the branches and thereafter the circular was issued. 20th September 2010 is the option exercising date commencement as per the circular of 15th September 2010. So, the first available date on which one could apply for option exercise was 20th September 2010.
From where did you get this date?
Please come to page 44 of the stay application. Clause 2 on that page. May I place it for your lordships? Offer of another option. In terms of the sanction of the government to implement the terms of settlement or joint note dated 27th April 2010, as advised by Indian Banks Association and approved by the Board of Directors of the bank in its meeting held on 28th August 2010, another option to become members of the pension fund under Allahabad Bank Employees Pension Regulations is hereby offered, pending required amendments of the said regulations of 1995, after necessary formalities to those employees or retired employees on superannuation or voluntarily under the VRS, families of deceased ex-employees who are eligible as per the said settlement or joint note dated 27th April 2010 to be exercised in bank's prescribed format in the manner described hereunder within a period of 60 days starting from 20th September 2010 up to 18th November 2010, both days inclusive. Any option received after 18th November or in any format other than the bank's prescribed format will not be valid in any case. So, the first date on which an employee or an heir or somebody else not could have applied under the form was 20th of September 2010.
So according to you, if we have understood correctly, beyond after this date, there is no application. If at all there is an application, it is prior to this.
6th September 2010.
So how does it change? What is the
number one? There was a time frame by which one had to refund the employer share of provident fund contributions with interest.
But that will always be later to his application.
Right. Now, that could only be, there was a time frame. Please come to page 45 now.
No, so is he saying that he will not do that?
No, the court has directed calculation. Court has directed calculation of his amount to be refunded.
We are trying to understand why you are agreed by the order. See, there is a time for exercising the option. You may say that on the day he exercised the option, there was no such option.
There was no such option.
But then just immediately within a week thereafter, you have come out with an order saying that you can exercise such an option.
On and from 20th September.
From a prospective
Particular
date,
date.
obviously. So what is the problem with the bank? If because no payment was to be made prior thereto, if any payment or refund was to be done, it was only subsequent thereto. So it could have been worked out. So what is
Number one, it modifies the form or not the joint discussion settlement. Number one. Number two, not the very fact whether he could have applied on that's now is doubted. Nobody had submitted a form on 20th September 2010, before 20th September 2010. And it's quite unlikely that the scheme could be modified at the branch level.
No, that is all right. We understand you don't have this discretion. But why the court's order you are challenging? How does it affect you? How does it affect the bank's interest so that it needs to be challenged? That is what we are trying to assess.
Monetarily,
we have understood what you are saying.
Monetarily, pension is much more than the provident fund.
Yes.
That's number one. That's the immediate civil consequence that the
So just before that, one query. Between 20th September 2010 and 18th November 2010, did he give any write-up following that? I have already given an option.
His first demand for justice was in 2012.
No, in between this period, he has not said that my application be considered or anything. First application is of
24th, serial number 8 on in the list of dates.
Page 27 of the lordship application.
24/1/2012.
Comes to page 27. This was the first application. It was also rejected on some another ground. Page 39.
So the honorable single judge, he has already
It was also a consent
reserved,
order.
already reserved your option to make a recovery from whatever you were required to recover.
He has to refund the employer's share of PF contributions with interest.
Which he has not done.
Not in terms of the honorable single judge's order, which is under challenge.
So has he done it?
No, not yet.
Has he made any application for making that payment?
No, he has done so. No, we have to calculate this. No, this may open a floodgate.
How can it?
Nobody knows. No, it's quite abnormal.
Prior, then only somebody may, if there is a prior application and there is a receiving by the bank authority, then only someone may be in a position.
But at the branch level, this was done only to eradicate the possibility of any other things taking place. So it's quite unlikely that at the branch level, somebody would modify the outcome of a joint exercise or not a joint bipartite settlement at the IBA level and not invite exercise of option.
That could not be. That your point we have understood.
That's the point.
What we are trying to understand is why the bank is so. Yes, so what is it you want to submit? Tell us.
Now, apropos this, please see that kindly consider the direction contained in the honorable single judge's order.
Yes.
And I place from paragraph 4 onwards, which is internal page 2 of the order. Learned advocate, it's paragraph 4. Learned advocate appearing in support of the aforesaid petition would, however, submit by drawing attention of this court to a circular issued by the Allahabad Bank on 15 September 2010 that the employees of the bank, including the erstwhile employees of Allahabad Bank, were given a further opportunity to exercise another option for opting for pension. By drawing attention of this court to the clause 4 of the office circular dated September 15, 2010 under the heading optional guideline clause 4.3, he would submit that option form was meant for use of employees who had retired on or after September 29, 1996, but before 27th April 2010. According to him, since the petitioner had retired within the aforesaid cutoff date, the petitioner was otherwise eligible for pension, especially having regard to the fact that the option form exercised by the petitioner in terms of the above circular on September 6, 2010 is an undisputed document which is available with the record of the respondent, he would submit that the said option form had been duly countersigned by the senior manager of the bank. On the issue of the option being exercised prior to issuance of the circular, he would submit that since the officials of the bank were aware with regard to the decision of the Allahabad Bank to permit the ex-employees to exercise the option forms were circulated, and having regard thereto, there is no irregularity in exercise of the aforesaid option, he would submit that above option read with circular creates a legal right in favor of the petitioner to be entitled to pension. But here I join issue. Learned senior advocate representing the respondent bank has not denied the aforesaid option being exercised by the petitioner as appearing at page 18 of the writ petition. He candidly submits that though the pension papers of the petitioner were processed, however, since the original option exercised by the petitioner in terms of the said regulation could not be traced, PPO had not been issued. Heard the learned advocates for the respective parties and considered the materials on record, noting that the petitioner was an employee of the bank who had been superannuated on June 30, 2006, and also noting that the respondents had already processed the petitioner's pension papers, and it is also an admitted position that the circular of 2010 was issued and a further option was given to the ex-employees of the bank to opt for pension. The petitioner was eligible in terms thereof, and having exercised the option as appearing at page 18 of the writ petition, though such exercise of option was prior to publication of aforesaid circular letter, I am of the view that since the above circular was introduced to implement the terms of settlement of 2010 as advised by IBA and approved by the Board of Directors of the bank in its meeting held on August 28, 2010, providing for a further opportunity to the employees or officers to become members of the pension fund under the said regulation, and noting that the same had the sanction of the central government and that the option exercised by the petitioner, though prior to the September 15, 2010, being duly countersigned by the manager of the bank, the case made out by the petitioner that since a decision to permit exercise of option by the ex-employees had been taken, the option form was circulated, appears to be a plausible explanation. Further, non-availability of the records of this case should not be a ground to deny the petitioner the opportunity to avail pensionary benefit, especially since the respondents had processed the petitioner's pension papers in tune with their pension regulation. Now, this is the second point not where I join issue. Having regard thereto,
it was not processed.
The records as brought from the banks, the South India office today, revealed that there was a process made. Now, that was placed before the court. But not the first and primary thing that was required to be done for the purpose of processing was refund of the amount. This has admittedly not been made. So, the circumstances under which the regulations came to be rather modified by the Honorable Court belies the sanctity of the scheme. For processing pension, one has to refund the amount first.
Where is receiving of option? Is it on record?
Yes, please come to page. I've annexed this at page 30, 26 and 30.
30. So this option form which he has submitted prior to decision which you have shown of 24/1, sorry, what is that decision?
2012, he made a demand for this.
15/9/2010. Prior to this decision, was any such form in existence?
That's the finding of the court, that there was a possibility of the forms being circulated.
Therefore, from this circular of 15/9/2010, can you point out that they say that a option form shall be circulated or anything like that?
Come to page 42. Please take the background. The last 3 lines. No, not necessary. Lordship may straightway come to page 44. Paragraph 3.1. Salient terms for offer of another option. Option will be accepted only from those.
So prior to this, also there was an option accepted.
That at one point of time, most of the employees of the banks had not opted for pension. Therefore, not that bipartite settlement for the officers took place in 2010.
Many had missed, so therefore it was.
Or not they thought that now pension is more benevolent than the provident fund.
So therefore, that form was in existence. It is not that the form was not.
This form came to be in existence probably between April 2010 to August 2010.
Correct, because that is the date on which
Decision or the settlement took place, and the board of directors accepted this in August 2010.
Connection with the appeal was filed.
there is a stay in the present appeal.
Yes, in the present appeal lordship, there is stay application.
No, is there a stay order?
No. But in fact,
Time lordship heard by you.
the contempt, the stay application was filed on October 25, 24th October 25. And it appears that on the same day a rule has been issued.
So when the judge has recorded in paragraph 5 that you have not denied this situation.
It was a lordship consented order, several occasions.
No, we brought the records from the south.
It was
So
before
that is
record
still
re-
not denied.
it was
The records revealed that there was a endorsement made for processing of the pension papers.
So that's still not denied.
No, that was there.
PPO was
No, when you say you are taking exception, therefore we are asking. That is a fact recorded. Otherwise, you would have filed a review.
No. It was there. Not we had submitted before the court the entire records.
So, is there any other such application with you?
But not the the as of date none. But not the original option form is untraceable.
So, how does that in any way prevent you from processing the thing? And if so, he could be asked to give a form afresh. If there is a requirement that he should disclose any information which is required in the form, then that we can clarify.
That form is prescribed. It is a fallout of a.
But you are saying it is loss. Therefore, we are saying whatever he has submitted, if it is not traceable.
Today the question is not whether he had slipped in this form somewhere or the other or not. But these circumstances are suspicious.
And where is the receiving? We have not seen the receiving.
But please come to page 30. But quite unlikely that at the branch level on 6th September 2010 somebody would receive a form.
Why, if in principle the settlement had already taken place, could have been received?
28th of August 2010, the board of directors had decided to adopt this.
Page 30.
30. Please come to me. I just read it for your lordship's consideration. I hereby declare that I have read and understood the terms of settlement or joint note dated 27th April 2010 for extending another option to join pension scheme under Allahabad Bank Employees Pension Scheme 1995. I have understood that the terms of settlement have been arrived at on the basis of the unions or associations offering to contribute 30% of the amount funding gap, initial funding gap, assessed for extending another option for joining the pension scheme. I am agreeable to the said contribution of 30% towards the funding gap and hereby voluntarily opt for bank's pension scheme under the Employees Pension Regulations 1995 as per the provisions of the said settlement or joint note. I undertake to refund the bank's contribution of provident fund together with accrued interest thereon paid to me on my retirement plus an amount equal to 56% of the bank's contribution to provident fund with interest received at the time of retirement being 30% of contribution towards the initial funding gap in terms of joint note of settlement dated so and settlement dated 27th April 2010. I request for commutation of pension to be declared for authentication if commutation is not desired. In terms of regulation 41 of the pension regulations, I hereby apply for commutation of 1/3 of pension admissible to me. I also enclose my medical examination report as per format so and so, since a period of 1 year has elapsed from the date of my retirement so and so. But this is there, it has a seal with
Yes, we have
signature.
read it. We have read it. We have read it.
Page 43 is the lordship terms and conditions.
Because that 27/4/2010, the settlement was already.
Settlement was there. But this is a fallout of settlement. All banks have the same format, no doubt about that. But not the very implementation of this settlement is from 15/7/2010 with the option exercising, first option exercising date being 20th September 2010. With a direction to refund the entire employer share with 56% as bridging the fund gap.
All that he is agreeable.
Funding gap lordship, we are agreeable because that is to be calculated by the authority after the expiry of
So if
60
we have
days.
understood,
within
there are
30
two
days.
submissions on your part, that one, it is not in accordance with the policy, which was declared on a particular date, and second, it is likely to open a floodgate.
And not it really, it of course covers the first point, it modifies the scheme.
So therefore, that is a part of the first submission.
The scheme has to be accepted in toto or not at all.
That we have understood. That is all you want to say something.
Kindly 2 or 3 lines, lordship. Kindly consider, lordship, page 30 and 39.
39.
39. 39, lordship, after the form was, lordship, fill up, it was not exercised by the bank, lordship. Representation was made to the authority and the rejection ground, lordship, kindly consider the receiving notes. Received, since you have not opted the pension under ABEPR 95.
Yes.
So earlier pension scheme was introduced, lordship, in the 1995. That was the reason, lordship. That's why, lordship, the application at page 30 was rejected. So it is not the ground, lordship, that the application was made prior to or any subsequent date.
No, this rejection had to be in terms of the 1995 regulations only.
So the acceptance of the application has been admitted by the authority. Now, lordship, kindly consider, lordship, page 43. As per my submission of my senior friend, lordship, that we have not, lordship, refunded the 30% amount. Because, lordship, it should be as per, lordship, 1.2.2c. Kindly consider, lordship, at page 43.
No, where is he saying that you have not refunded?
And, lordship, the terms, lordship, kindly consider for rejection. After 18 November, it is there, lordship, page 44.
He has not argued anything that you have not refunded. That's not his case.
And, lordship, regarding, lordship,
there is already a direction.
Page 39 endorsement is an addition. I'm sorry.
Kindly consider, lordship, page 44, lordship, when the application cannot be accepted by the authority. Specifically, it has been mentioned, lordship, that after 18 November. And in terms of, lordship, the action of points, lordship, page 48, the authority, lordship, on spot, lordship, can reject the application, and it was accepted. They have admitted, lordship, in the representation made by the authority and last occasion before the learned single judge also. And the record placed before the learned single judge, lordship, PPO also prepared before the
page 48.
40 kindly comes to, lordship, page 44 first.
No,
The last
you were saying that they could have rejected it on the spot.
No. It says, lordship, at page 45. Unless it is not accepted.
What is there?
Page 48, lordship, kindly comes to, lordship, page 5.5.18.
How can this apply? This has come into existence subsequently. What? This you are relying upon, it has come much after you have submitted your option. How they could have taken action under this?
Now, lordship, regarding, lordship, prior to the date, lordship, it was initiated.
You are actually relying on 5.1.8.
No, lordship, kindly consider, lordship, 5.1.8.
How can you rely on this?
According to the.
This had not seen the light of day when you made your application. Where is the question of this applying?
No, if it is lordship, if there is any discrepancy, the authority will not accept the application. It is there.
Discrepancy.
And lordship, kindly consider lordship page 44, the last line, page 2.2. After lordship 18 November, they will not accept the application. That is there. But prior lordship, at the form was lordship at existence, it was accepted by the authority. August lordship, it was.
All right, we've heard this.
Item 17.
Item 17, but I'm for the appellant rate petitioner. Yes. But I am the appellant writ petitioner. But we are challenging the impugned order. Dated 9th of July 2025. But wherein my grievance with regard to non-sanctioning or non-regularizing has been denied. The sum and substance is, since 2007 I had been working, and in 2018 my service got terminated on the score that the said post was not sanctioned. Our humble,
Where is that termination of?
But if your lordship kindly takes up if your lordship kindly comes to page 120.
140.
120.
This is not your termination order.
Yes, my lord. I'll come to that.
No, you said there is a termination by assigning a reason that your appointment was against a non-sanctioned.
Yes, my lord.
This is not the termination order.
No, my lord. There's a backstory to it. My lord, earlier, my lord, I had preferred a writ of application with a prayer for pay hike.
With a prayer for
pay hike.
pay hike.
But that reference is with that letter, my lord. My lord, in that writ petition, my lord, this honorable court had been pleased to direct page 110 is the order of the honorable single judge, wherein a direction was passed that the respondents, that the liberty was granted to the petitioner to seek for permanent absorption.
The substantial prayer was for
pay hike.
a higher salary, and
Yes.
the direction was
Yes.
given for considering you for absorption.
Yes.
So in effect, your higher salary claim was not entertained by the court.
Yes, not entertained. And thereafter, my lord, this honorable court has been pleased to grant us liberty to make an application before the authority for grant of absorption. Page 111 is the relevant paragraph.
Yes.
Now, this direction was passed that the decision by the authority should be taken by 25th of December 2018.
Yes.
Now, my lord, page 120, the page I was referring to,
Yes.
is beyond the time limit that has been prescribed by the honorable court.
No, but there is no termination on the, you said that it was terminated by assigning a reason that your appointment is against a non-sanctioned post.
Yes, my lord, they have said it. There was no sanctioned secretarial assistant.
This is not a termination order. You said there is a
Yes,
termination order.
The
Is there a
appropriate-
termination order? We are asking you again.
No, that has not been renewed. That would be the perfect word.
So there is no order terminating you.
Yes, my service was not extended or renewed. My lord. Now, my lord, this order of the authorities comes after lapse of 3 months, nearly over 3 months. But this order was challenged in this writ petition.
This is the order impugned in the present writ proceeding.
Yes.
5/3/2019.
Yes, 5/3/2019. The honorable single judge directed them to take a decision preferably by 25th of December 2018, and they take a decision on 5th of March 2019.
Yes.
Saying that this is the grounds. Well, assailing that, but we filed the writ petition, and this was heard extensively, my lord, and a decision comes wherein the honorable court says that the appointment is illegal, whereas it could be said to be irregular at maximum. even if not regular. Now, my lord, kindly comes to page 80. My lord, may I say the facts first? Page 80. But this is a notification where the institute asked the union government for sanctioning certain positions as they were lying vacant for quite some time. But I was working there on contractual basis since
Since 2007.
2007. Now, my lord, by virtue of this notification exchanging letters at page 80 and 82 and 83.
80 is much before you were appointed.
Yes, my lord. This is the steps that they have taken.
No, where is the sanction order for that post?
My lord, coming to that. My lord, page 80 is the request letter made by the authorities.
Yes.
My lord, kindly comes to page 80 to 81. Bottom. Yes. Here, my lord, the board has approved the above two proposals. We shall be grateful for your favor and consideration. Page 82 is the correspondence by the Ministry of the Union saying, no, you please convert the 12 posts into 6 posts of secretarial assistant. Out of the 6 assistants, my lord, I am one of them, presently working.
No. So you are
This
saying
nomenclature is missing.
The board's approval is being recorded at page 81. To which proposal?
But the proposal that
the 12 post of stenographer,
yes,
against that post somebody may be appointed as
yes,
a secretarial assistant.
Yes. Now, my lord, page 83 is the.
So there is no creation of post for secretary. You have been appointed as secretarial assistant.
Yes, but page 83. I'm coming to that. That 12 posts of stenographers have been converted to secretarial assistants. Now, kindly see the subject, my lord. Conversion of 12 vacant posts of stenographers to 6 posts of secretarial assistants. So this is acknowledged by them. Now, my lord, if your lordship kindly takes up page 154.
Are you saying where is the conversion? You can't just read the subject and say that this is a letter converting the post. This is not the way to place a document in court.
Lord, may I read?
Yes.
But I'm directed to refer to CAO and Secretary to Board IIM Calcutta's letter dated such.
Read paragraph 2, sir. What has been approved?
But paragraph 1A.
Yes, regarding paragraph 1A, it is stated in para 2.
Yes, my lord. If a post is held in abeyance or remain unfilled for the period of 1 year or more, it would be deemed to be abolished. Number in 2006, this letter has been issued.
Yes.
And
where is the approval? The subject says conversion. That does not mean it was converted. You said that it has been converted.
May I say this?
Can you say converted by just reading the subject?
I'm coming to that.
I'm not coming to that. You said that this has been converted.
The letter also says
submission.
I apologize for it, if I'm making wrong statement. But if the institute doesn't act upon its own resolution,
whatever it may be, there is no conversion.
My lord,
till this date, there is no conversion. Now what is your case?
Page 154
yes,
is the advertisement of secretarial assistants. 154.
Yes.
Is the advertisement by which I participate in that set examination. On the bottom line says, well, secretarial assistant 6 posts, contractual.
Yes. That they are not disputing. The only issue is whether it was a sanctioned post or just on contract basis you were appointed.
Yes, my lord. Now,
there is no dispute that
the problem, my lord, is the last part of the paragraph, my lord.
Last part
of the paragraph of the third paragraph qualification.
Yes.
Well, graduate having completed secretary's course from a reputed institute should be a computer literate and good in communication skills with adequate proficiency in English. Experience at least 5 to 10 years experience. Age, upper age limit below 40 years, emolument such and such. Now, my lord, the last paragraph, the above qualification, there is a relaxation to that, my lord. Above qualification, experience, and the age criteria may be relaxed in case of exception of candidates with outstanding hands-on experience.
Yes.
Interested candidates may apply such and such.
Yes.
Now, my lord, I was working there before this advertisement. And after being selected, my extension was for a period of 10 years, my lord. But there was no disciplinary proceeding against me. There was no adverse marks against me. My lord, when I claimed for regularization, they said there is no sanction post and my term cannot be renewed after 2018 December 31st. My lord, if your lordship kindly takes up page 127 is the letter by me to grant me the relaxation of age, because at that point of time I was 48, and on this sole basis, my lord, the Honorable Court has held that this appointment is illegal.
Page 120 is the relaxation.
127, my lord. I had written to them. No, I'm sorry, my lord, not 127, my lord. Kindly apply. I can enter my apology, my lord. No, 152, my lord. 152, my lord. Thank you. This was my prayer to them to grant me relaxation, because I was working there since 2003.
Where is the relaxation? You were just now showing some document that it has been relaxed. Where is that relaxation?
But I'm coming to that. The first email at 154 is the advertisement. 152 is my application requesting them to grant me relaxation. And my lord, thereafter, my lord, I have been granted the joining letter at page 85. From thereby, my lord, when I am being granted joining, but that simplifies that I have been granted relaxation to join.
So it is a presumption, your presumption.
Yes.
Or there is an order.
No, there's a presumption that I have been
There is
granted.
no order relaxing the age criteria.
No. Page 85 is my joining letter, my lord, with reference to the interview dated such and such at our institute. We are pleased to offer you the contractual appointment to the post of secretary assistant and the following criteria. But this goes on, my lord.
But you were showing some advertisement.
Yes, ma'am. 154, my lord. Page 154 is the advertisement. For the set
What
post,
is the date of this advertisement?
but the date of advertisement is, my lord, 19th of September 2009. 19.
So you were not appointed after this advertisement.
Yes, this is the advertisement. Because if your lordship kindly takes up page 152.
Sir, just now you said this advertisement is of 2009. Your appointment letter you are showing of 2007.
2007. I'm sorry, my lord.
What is the date? Give us the date.
But if you lot
19 September 2007, the advertisement.
Well, page 152 is the reference there. So Lordship kindly takes up 152. The reference is there, my lord.
Where is that application that you had given?
My lord, page 152. Just 2 days after the advertisement was published.
And this advertisement, does it lay down any procedure for making the recruitment?
But the qualification is there that I need to be qualified with regard to experience, complete technical course from a reputed institute, should be computer literate and good in communication skills with adequate proficiency in English. If my lord, this advertisement would have not been there, it is certainly an illegal appointment. Now, my lord, page 85 is my date of joining. Now, my lord, if your lordship kindly takes up page 102 for a once, my lord. This is a continuation of extension. I'll not trouble much, but I'll take your lordship to paragraph 17, my lord, of the notification, my lord.
And where is the extension prior to this? In between 2007 and 2018?
Lord, if your lordship kindly takes up page 98 is an extension. 97 is an extension. 96 is an extension. All prior pages, my lord, after my appointment, which is at page 85.
Yes.
Now, my lord, paragraph 17 of this set at page 104 that says that during the period of your engagement with IIMC, you will devote your whole time attention. Now, my lord, in order to seek regularization, the first point that the Honorable Supreme Court has repeatedly held that the nature of work has to be taken into consideration. The nature of work is perennial in nature.
Yes.
My lord, since I was devoting my whole time to this institute, my lord, unblemished career, my lord, I had in that institute, no red markings so far, my lord, to the knowledge, my lord. Now, my lord, at page 1, if your lordship can take up page 99 for once, my lord. But this is a letter that the ministry writes to the authorities, my lord, that I am directed to enclose a letter that is such and such received from the employees working in the Institute of Management, Calcutta, for the last 8 years as an employee contractual under the payroll of the institute without any break for taking appropriate steps, necessary action in this regard. But even after this letter, the institute did not do anything. Certainly, there was no strict direction that you have to do it, but there was a intention behind the authorities to consider it. Now, page 100, my lord, also specifies that no appointment to be regularized if that is not advertised through newspapers. So here there was an advertisement.
Yes.
My lord, the honorable single judge dismissed my application on the presumption that the appointment was illegal because I was appointed at the age of 48 years. But suddenly I would have not got a good case or not at all a case if the advertisement at page 154 was missing or not there. But page 43 of my memo, paragraph 46 of the impugned judgment, but goes on to say that the appointment was illegal because of the fact that I was appointed at the age of 48 years. Though relaxation was allowed on the basis of the advertisement itself. And 47, also the same thing, that the contractual employment petition was renewed on revised emoluments on expiry of each term on the self-same terms without any demur or protest or claim. Now, when an appointment is given to me, I cannot protest because the power of bargain does not have with the employee.
Yes.
And in nomenclature, that sanctioned post was not in the advertisement, but the nature of work was perennial nature and whole time. These are the facts, but we had on the earlier occasion filed our list of dates and the.
So your case is that after a due advertisement, you were appointed. Conscious decision was taken by the institute to convert certain posts in view thereof, in view of the perennial nature of work, and since you have continued for 11 years, you should be regularized. Now, what are you relying on?
But I'm relying on certain citations.
Which one?
Undoubtedly, Uma Devi. But Uma Devi.
Paragraph 53.
Yes, my lord.
Yes.
If that would have been declared irregular. Now, my lord, in this case, if the relaxation.
So what is the difference between illegal and irregular?
My lord, irregular because. My lord, illegal because if there was no advertisement, if my candidature or my nature of work was to be considered since 2003, then it is illegal, certainly illegal. Backdoor entry. But when there is an advertisement, my lord, and I have been made to work with a conscious decision upon by them, but that cannot be termed as illegal.
So Uma Devi 53, which other judge?
But I have read upon.
Relying on Jago also.
Yes, my lord. Jago also, Shripal also.
And Dharam Singh, there is one other judgment after Jago.
Dharam Singh.
Yes.
But we have relied upon everyone.
Dharam Singh or Dharamveer Singh, what is the name?
But
after Jago's judgment.
Yes, my lord. I'm coming to that.
By the same honorable judge.
But Dharam Singh, my lord, is not with me at this moment.
Anyway, no problem.
My lord, I'll just refer it to my lord. But the honorable
after
this court also
after Jago's judgment, the same honorable judge has delivered a judgment considering Uma Devi and Jago. That is in Dharam Singh or Dharamveer Singh, something like yes. Very recent judgment.
Yes, my lord. September 2025, most probably, my lord. But I have not annexed to this, my lord. Yes.
Jago is noted.
Yes, Jago is noted.
There is one after that also.
Yes, yes. Jago has been distinguished because Uma Devi is of 5 judges bench and Jago is of 2 judges bench. That is the.
Devi has not been diluted in the judgment of Jago. In Jago, the apex court has said that it is often being misrepresented, misinterpreted.
Yes,
it is not.
Prayer,
it is not in any way diluting the effect of Uma Devi or paragraph 53, the requirements therein. The apex court in some paragraph has expressed language that it is often being misinterpreted.
Yes.
And then thereafter the relief has been granted,
yes,
considering the facts of the case therein, where they were in employment since 90s.
Yes.
And the sanction was being moved by the department time and again. all steps were being taken. Those were the
Yes,
facts,
my lord.
if we remember correctly.
Yes, my lord. That was our humble prayer, my lord, before this honorable court, that Uma Devi is not in any way curtailed by these judgments. But we have relied upon the judgment passed by this honorable court, as well as, my lord, the other high courts, my lord, where, my lord, the stress has been given the nature of work. Even if the nomenclature sanctioned is not there, you have to be regularized.
Where is that judgment?
My lord. Tada. But if Lordship kindly comes to page 230 of my compilation, my lord. So this is also a division bench judgment, my lord. Paragraph.
Page 230.
Yes, my lord.
This is not our division bench.
No. I'm saying our coordinate division.
Yes.
Yes. On the page. Paragraph 15 and 16. Sir. Okay, sir. Paragraph 16 would be relevant.
Yes. There also he was working as a game spion. There was no such sanction
Yes,
post.
but this is the Dharam Singh judgment, my lord.
Yes, this is the letter judgment.
Spirit lies the same, my lord.
There is any policy in this institute that where there is a continuous service on a particular post and that post does not exist, how they are to be regularized, if at all they are to be regularized?
Well, that is what the ministry has asked them to do. They are silent on it.
Ask them to do is a different thing.
Yes,
We are
ma'am.
asking you, is there any such
As to
policy?
my knowledge, but I do not have any.
So you are not relying on any such policy.
No, my lords, because I don't have that, but I will not. But Jago's judgment at page 135. Paragraph 10. May I read?
Page.
Page 135.
All right,
Item number 31.
Before we proceed any further, how many appellants are there?
54 heads, my lord.
So how he can represent the others?
Sir,
He has taken no objection from us.
my lord, I have authorizations, my lord.
From all the 53 persons?
All 54.
You have filed it?
I can submit if you are kindly order me.
How can you? You are not a lawyer.
No,
How
my
they
lord.
can authorize you to appear on their behalf?
My lord, we are not being able to manage the law. I'm not able to manage the fees of the Rani advocates.
No, we understand and we appreciate what you are saying. We understand and we appreciate what you are saying. But you can appear only for yourself. How you can appear for others?
My lord, they have been authorized me.
How they can? You please try to understand what we are saying. You are welcome to address on your behalf how the others will be represented.
Okay, my lord. If you kindly allow me, I am telling on myself.
And what about the others? Can we decide it in absence of the others?
My lord, what is the alternative, my lord? We are not being able to.
We are not here to advise you, sir. We are not here to advise you.
My lord, out of 54, almost all are in bedridden condition. All are about nearer to 80 years.
That is not what we are asking you. We are trying to understand how the representation is to be ensured. In the proceeding, you cannot represent another person. You can appear in person. You are more than welcome to appear in person and we will hear you. But can the appeal be heard piecemeal? That for one person you make an argument today and for 53 somebody else will make argument on some other day. Can it be done like this?
My lord, what is the solution, my lord?
That is not for us to tell you.
My lord, then we will die by this time and this case will automatically be dismissed.
My lord, we can do one thing, my lord. I am the advocate on record, my lord, in respect of this. Lord, if he submits, Lord, I will withdraw that notice, my lord, that has not been filed in the department as yet. Lord, we will support his submission.
You have not filed no objection.
No objection has not yet been filed. If he submits before,
But you were telling us that he has filed no objection.
With me.
But only for himself. But not for others. So you will represent the others. Then you make your submission first. We will hear him later.
Since he is, today I am not ready, my lord, but if he is,
We are not ready. You are the lawyer and in the.
my lord, he has requested me to assist him, so because he is hearing it. That's why, my lord, I have came. Otherwise, my lord, I couldn't have come, my lord, because he has obtained no objection.
My lord, we have finding no other alternative, my lord. We have appeared here. We will die by one of. I am also cancer patient. Anytime I may die. Like me, others are somebody are in bedridden condition, somebody have been suffering from incurable diseases. It is not possible for them to hear.
Apart from you, there are 53 appellants.
Yes, ma'am.
All the 53 appellants are entitled to representation in the proceeding. Somebody has to tell the court their case, make out the case and present the case on their behalf. Can we ignore the 53 persons?
Even if they authorize me, on behalf of them, I have filed affidavits.
Again, we are telling you, you are more than welcome to argue your case, but you cannot represent the other 53 appellants.
If my case is, my lord, if my case is goes in favor of me, then that's the benefit will not be extended to them.
And if it goes against you, then
against all.
Very good, without their representation. No, please let him. Then without hearing them, they may have something better to say.
Yes, sir. Yes, my lord.
See why we are saying. This is why we are asking you.
How it is to be done?
No, okay, my lord. I represented wrongly. My lord, I may kindly be allowed to represent me, and next day another appeal, another advocate I will see if Mr. Dow will be given time to represent them.
This piecemeal hearing we will not do. Why you are not ready? And you have not told him that he cannot represent all the persons.
We have told him, but my lord,
You are helpless.
Sir,
You have taken the wakalatnama of 53 persons and you are helpless.
my lord, this matter has been hard. Three benches, my lord.
We are not asking the history. You are here as a lawyer, you are appearing in this proceeding. You are representing 54 persons. One may have decided to argue his case on his own behalf. So what is your responsibility to the remaining 53?
In respect of all 53, because he is the leader in that, my lord, employees federation.
So therefore, now again you are saying oh, no objection. Every time if we ask you something, you will take an oscillating stand. Just now you said we have not filed. I will represent. Now you are saying he has taken NOC for all of us. What is going on? How can you?
My lord, what is the solution then, my lord?
Solution
Solution.
আপনি নিজেরটা রিপ্রেজেন্ট করুন, বাকি 53টা আমি করব,
করে দেবেন, হ্যাঁ।
ঠিক আছে? তো সেটা আমি জজ সাহেবকে বলবো
Sir,
যে আপনি সবারটা রিপ্রেজেন্ট করতে পারেন।
Okay, my lord, may I kindly be allowed to represent myself today?
Only by hearing one appellant can the matter be decided.
No. Yes, sir.
Can it be decided?
No.
It cannot be. Please try to understand. We have fixed it because you mentioned. But this problem is there. How to resolve that problem? We don't know what is transpiring between you and your lawyer. We are not going to look into that. That is a privileged communication. Once he's saying all of them have withdrawn, once he's saying he will represent 53, we don't know what the fact is.
My lord, then fix up the next week. If there is no other way than to advocate's pleading, then
No, you may make your submission. You even next week you can make your submission.
Okay.
On your behalf, you can make all the submission and we will consider. But how this can proceed like this?
Okay, my lord, I may start, will you kindly allow me?
Yes, what is it?
My lord, the appeal.
So no objection has not been filed.
My lord.
You are sure? Yes.
My lord, the appeal is preferred against the judgment and order of the Honorable Justice Arijit Banerjee dated 29th June 2017. The subject matter of the case is denial of the pensionary benefits.
What is the date of the order passed by the Honorable Single Judge?
29 June 2017.
Which page?
90.
Volume number 3. Volume number 3.
(705) it starts, yes. Yes.
My lord, our prayer under each petition was rejected on main three grounds. First one, my lord, the non-submission of option to the pension regulation 2002, fence-sitter, latecomer, number one. Number two, withdrawn of CPM amount without reservation, protest or demand. Third point was no explanation for delayed approach. My lord, I am telling from point wise. My lord, the allegation of non-submission option is not correct. Being government servants, we are entitled to get government pension. In support of that, my lord, I will kindly pray to see the GO dated 20th October 71, page number 55. May I read out my
135.
volume number 1,
Page.
page number 556.
Huh?
56.
Volume 1. All right.
May I read out, my lord?
Yes.
I am directed to say that this department has been advised by the officer of government that the DSTB employees are government servants. Consequently, the West Bengal Service Temporary and Quasi-Permanent Service and Service with Permanent Status Rules 1967 and the West Bengal Government Servants Conduct Rules 1959 shall apply to the said employees. Necessary further action may be taken and all concerned informed accordingly. My lord, this is issued after concurrence of Finance Department. My lord, then at that point, when we joined the corporation, at that point of time, it was named as Durgapur State Transport Service, and it was being governed directly by the Home Department. Thereafter, my lord, it was renamed as DSTB. Order may kindly be seen, my lord, in page 50 and 51. Shall I read, my lord? In pursuance of the paragraph 2 of the department resolution number such and such 23rd February 67 published at pages such and such of the February, governor is pleased hereby to appoint with effect from 15th August 67 the following persons, the members. Before that paragraph, my lord, the governor is pleased hereby to establish the Durgapur State Transport Board with effect from 15th August 67. My lord, here board has been established and members have been appointed. And the management has been vested on the board, keeping full control over the affairs of the corporation. Then it was, my lord, in 26 May 1970, this department was declared as purely departmental activity. My lord, kindly see 54, 55. Before my lord, I am directed to refer letter number such and such from your accounts officer, enclosing a copy of your office letter dated such and such, and to say as follows: as Durgapur State Transport Board is a purely departmental undertaking, there is no question of appointment of any non-official member of its board. The Durgapur State Transport Board are being advised that all sanctions issued and contracts executed by it should be expressed to be issued, made by or on behalf of the governor of West Bengal. That means, my lord, it was purely department matter. Thereafter, in 71, the order I read out, my lord, the government servant. Then after, my lord, in December 73, 4 December 73, under a notification, a corporation was established. My lord, kindly see page number 64. Whereas the board of directors of Durgapur Transport Corporation established under this department is no, sorry, my lord, this is in exercise, my lord, 63, in exercise of the power conferred under section 34 Act, after consultation with Durgapur State Transport Corporation, a board of and because established under section 3 of the said act, therein after called as corporation hereby directs that pending the framing of the material service. My lord, that is not my lord. Sorry, my lord. বলতে গেল my lord, 57, my lord. Sorry, my lord. 57. Dated 4 December 73. In exercise of the power conferred by section 3 of the Road Transport Corporation Act, the governor having regard to the under the advantage to the public, trade and industry by complement of road transport in the areas comprising the district Birbhum, Bardhaman, Bankura, Midnapur, and Purulia in West Bengal. The desirability of coordinating the road transport with rail transport in the said areas and the disability of the extending the improving the facilities of the road transport in the said areas and of providing an efficient and occupational system road transport is pleased hereby to establish with effect of 7 December 73 a road transport in the name of Durgapur State Transport Corporation. But in this notification, the service status of the DSTS, DSTB employees were not clarified here. What will be the status? They are government employees. But my lord, their service status is protected under section 47 B1F of the RTC Act. It is available, my lord, under page 59. 59 F. F, my lord, from last third paragraph. Persons employed by the state government in connection with the state undertaking and continuing in office immediately before the established corporation. No, and terms and conditions not less advantageous than what they were entitled to immediately before such establishment, as may be determined by the corporation. My lord, it means the service status advantages we avail are protected under this act.
You are referring to page 69.
My lord?
Page 69.
Page 69. 59, my lord. 59.
That's why we can't find what he is reading. Which provision? 47B.
47B F. My lord, from last third paragraph.
47?
From last side, third paragraph. Third paragraph.
47B1 F.
F. 47B1.
Subclause F.
Disposed.
My lord, my lord, the question may be whether we avail the government's facilities. Whether. Kindly see my lord, page number 69. My lord, kindly see page 69. We have to inform MD, it is MD's letter to the government. Managing Director's letter. We have to inform you that while established 1963 Durgapur State Transport Service, an organization purely under the administrative control of the government of West Bengal. In 67, Durgapur State Transport Service was renamed as Durgapur State Transport Board, but still it was under the administrative control of the government of West Bengal. The employees entered into the service of this organization till 6/12/73, that is prior to conversion to Durgapur State Transport Corporation on 7/12/73, used to enjoy all the status and facilities of the government employees. In this connection, I am to enclose here with a copy of the letter dated 20/10/71, my lord, which I read out as government servant. My lord, under these aspects, we deserve the pension at par with the government. In this connection, my lord, the first pension case, the observation and findings of the Honorable Court was there. Shall I read, my lord? In the first pension case of the SBSTC. First pension case, our case is third one of similar category. We are the employee of DSTS, DSTV period. The first pension case was filed by the same period 60 heads. In that case, it is clearly stated that we are government employees. There was we have brought from government to corporation. We are deserve the benefit of 47B.
When did you retire?
I retired in 2005.
All the petitioners?
No, madam. They retired within 2009.
All before 2009?
54. All 54.
Between which year to which year? Who has retired the earliest?
Madam.
Between which year to which year? 2009 is the last.
Madam.
Who has retired at the first?
Who retired at the first? My lord, this is not a recording date. But we joined corporation in between 1963 August to November 73 and retired by 2009. The pension regulation was formulated in 2002. My lord, shall I read out the judgment of the case of the previous case?
How is that relevant? How that is relevant?
Relevant because of the fact they were also government period, they have challenged the decision of non-implementation.
You are not party to that writ petition.
No,
so that is not applicable.
Okay, my lord. Then, my lord, under these records, it is clear that we are entitled to pension at government rate, and that for that need not submit any option.
Where is that? Show us that communication.
And a government servants is declaration.
Which document said that option is not required to be?
This is my observation.
You are submitting that?
Yeah, I am submitting my. Yes, sir. But as because the government has declared that we are guided under the state government of West Bengal Servant Acts, then it is obviously that we are entitled to their pension.
So you did not get any pension?
No, sir. No, my lord. No pension.
No, nothing for retirement?
Nothing, sir. No pension. Even CPF linked to pension. That is, we are not getting. Contributory Provident Fund linked pension is there.
Oh, so you have got that benefit?
We are not getting so also.
Any retiral benefit was given to you or not?
Only gratuity and CPF benefit.
So CPF and gratuity was given?
Yes, CPF benefit.
On retirement? And you have accepted.
I accepted, my lord.
Yes.
Except with objection, my lord. Accepted with objection. Objection letter is here. I will see you, my lord.
Show us the objection letter.
Yes. Objection letter. My lord, third volume. Volume number 3, my lord.
Third volume. Where is the objection?
685.
668.
685.
685.
685. My lord, shall I read out?
We are reading, don't worry.
Okay.
This is submitted by which petitioner?
Myself, I am the prisoner. Another one, 2 example. We have enclosed 2 exact examples.
So what is your date of retirement?
I was retired on 30th October 2005.
So such objection has been given by all the 54 petitioners.
Yes, my lord. I'm not sure, but most of the petitioner has submitted option. But one thing, we have got CPF amount and gratuity.
You are petitioner number 1.
I am CPF number 1.
Petitioner number 1.
My lord, but the CPF benefit, within the CPF benefit, there is a scheme of pension. We are not giving that. My lord, it is to be noted kindly. The CPF we got without, my lord, CPF amount we received, but without pension. Pension means CPF linked pension is there, which are being.
Where is that?
My lord.
Where is that scheme?
Scheme under the Employees Provident Fund scheme. EPS 95.
EPF scheme.
EPF scheme, my lord. It is linked with the CPF scheme, contributory provident fund scheme. Out of the contribution of the employer, 8.33 goes to that fund.
Any EPF pension linked scheme was declared by the corporation.
No, man, that's been adopted by the corporation.
Where is that adoption?
Resolution. Government बोलो ना जाम रहे देखो 8 26 2 Kindly see my word page action 9x 109 and 110. volume number 1. You see 110 type there. My lord, being it is compulsory, my lord.
Page 110.
110. Volume 1, my lord.
110.
My lord, it is an confusing decision.
No, this board is saying it be introduced. When it was introduced?
It was into 1995.
Show us that document.
That is what an act provision, my lord. That is act provision. That is provision. That is the provision is under the Employees Provident Fund Act. It was implemented in SBSTC Act from that time. But
All right.
But it is this regulation was taken only to not to implement pension regulation. My lord, then my submission is but another point, my lord, in terms of the provision of service regulation, it is my lord, it is to show, my lord. Kindly see my service regulation 20 and 24. Service regulation.
No, this is not in the this is not in the record.
They are record in the case of earlier in
Confined to the record.
No.
Don't hand papers like that.
No. Yeah, my lord, the SBSTC employees pension regulations, which is the main subject matter.
No, NB, you are not employee of NB. You are of South Bengal. You are not of North Bengal Transport Corporation.
No, not Bengal. We are South Bengal.
Then why are you reading North Bengal Transport Corporation?
No, my lord, never read it. I never read, my lord.
You are going to refer to NBTC?
No, my lord. I am going to refer the pension regulation formulated for SBSTC, for South Bengal.
When?
It was formulated on March
2002.
2002. On March 2002.
That is not in dispute.
No,
that is not.
That is dispute, my lord. That is the dispute.
That is not in dispute. They don't say that we did not formulate. They say we formulated, but only 189 people applied, so we withdrew. They don't say they did not formulate, so that's not in dispute.
My lord, now my submission is this, my lord. They have formulated the scheme at lesser advantageous than the government employee.
That is all right. That is all right. There's no dispute about that. We have seen that issue. Don't worry.
No, my lord. That dispute is gone to the court and it is over. That
See,
the decision taken was
2002, they came out with a pension scheme.
yes, my lord.
They invited option.
Yes, my lord.
Very few people submitted their option. They withdrew it. In the please. In the meantime, some of you said that it is disadvantageous. It should be at par with the state government. So this is not in dispute. This fact is known. There is no dispute about this.
My lord, when the pension regulation was formulated with lesser advantageous, invited options. Corporation invited options from the employees. Only 60 heads opted this scheme.
189.
What government is telling 189.
Huh?
Corporation is telling 189.
Yes.
If it is admitted, my lord, without going to that point, major employees did not opt it. Then two things, my lord, that there may be two reasons. One, either it is not circulated properly, or there was a raised dispute to consider this scheme. Firstly, it was circulated under Ganashakti and Ajkal, the lowest circulated and party-sponsored paper. Secondly, after inviting option within 9 days, the petitioners, through the union, disputed the matter and requested to review it. That was, my lord. Firstly, my lord, before notification, we submitted dispute stating our eligibility in terms of GO and in terms of the RTC Act on 13 June 2002. Then, my lord, within 9 days of inviting option, my lord, these are available in page 105 to 108. Our objection, my lord.
Before the union, through the union, you have submitted your objection.
Here is, my lord.
That is at page 102.
That is no,
At page 102 and 106.
102, 105 and 108. And we were waiting at the response of the corporation. We made the managing director told that the option is given with a note that this is without prejudice to our right of getting government pension. They did not.
That pension scheme was not published in the Gazette.
Gazette, but my lord, Gazette, what many people can see Gazette. Secondly, it should be, well, option should be invited with the leading the newspaper.
Yes.
Ganashakti and Ajkal is not leading newspaper, my lord.
All right, that we have understood.
Then after that, we were waiting for the response. They did not respond. And this decision was taken, which is added, my lord, on page 110. Here, my lord, the heading, agenda of the notice to consider and approve proposal to introducing it. It is the agenda. Decision is not to implement, and not implemented. My lord, what is our thinking? Why you did not object? My lord, it was apprehended. If we submit option without raising any dispute, it may be treated that we have willingly surrendered our entitlement of pension.
We have understood. Don't worry. Now proceed further. That we have understood.
Okay, my lord. Then, my lord, it was not implemented. 60 heads went to court of the similarly situated persons.
Some petition 13475 or something like.
Yes, my lord. Yes, my lord.
What is the number? 13475.
13475
Yes.
W. My lord, and we were continuously making correspondence.
No, you were not party in that writ petition.
No, my lord.
No.
We are taking the advantage of the judgment of the case. We are not the party. My lord, then we were continuing correspondence with the government and the corporation. My lord.
13475 is of which year?
Which is, my lord?
It is of which year, that writ petition?
Oh, that is 2003, my lord. 2003. 2003.
So therefore, you said that that benefit should be extended to you also.
No, my lord, that is another point, my lord. There is another, our arguments is there. My lord, we will continue correspondence with the government and the corporation. On 17th December 2005, my lord, Finance Department informed that the matter has duly been considered. My lord, kindly see page number 146 of volume number 1. The undersigned is directed to refer to his letter number such and such, aforesaid subject, and to say that the matter has duly been considered sympathetically by the government in finance department, and necessary steps are being taken for early settlement of the cases as referred by the transport department. He is requested to contact his transport.
So this is in response to the union's
Finance representation, they have considered the case sympathetically. Then, my lord, thereafter on 25th April 2008, the first pension case was disposed of by the Honorable Justice Pratap Rai. Honorable Justice Pratap Kumar Rai.
Yes, 13475.
13475. My lord, there is main judgment which we want to rely. Kindly see, my lord, page number 158, 166. 158, 158. Point number
158.
158.
This is part of the judgment.
Yes, my lord. Part of judgment, my lord. First pension. We can admit fact that all the writ petitioners are.
What is this? This is not judgment. 158. 158 is not the judgment.
It's from 156.
158.
This is judgment.
Yes, my lord. This started from page.
This typed copy of judgment.
Started from 156 page. My lord, page number 18. My lord, 165. 166, my sorry. 166.
In this case, the court held that once option has been invited, there is no question of going back. This is what has been held by the court. You have invited option, they have given the option, therefore now you cannot go back. And therefore, a direction was issued to give the benefit of the pension scheme introduced in March 2002. This is what you are trying to say?
My lord, this decision of the government corporation was nullified by the in the case of 1345.
That is what we are saying. That is exactly what we are saying. The court said you cannot go back.
No, my lord, in our case, no. In the case of the first pension case.
Correct. In 13457.
Decision was
13475. The court said that you cannot withdraw the pension scheme.
No,
that decision the court has interfered with.
No, my lord, kindly see the 52.
Only thing that you may have the power, the discretion to withdraw the person who have already acted upon.
Correct. Therefore, you cannot go back because they have already given.
The persons who already acted.
They have all.
Yeah, my lord, kindly see the page number 170 and 71.
170.
Kindly 170 and 70. 170 and 171. My lord, last pair. Court decision of 8 April 2003 is a decision passed without jurisdiction to nullify the pension regulation 2 as effected from 1st April. In respect of the retired employees are concerned, are the reasons that once on due approval of board and sanction of state government, when any regulation is framed and notified, same become a statutory regulation in accession to the power under the Transport Corporation Act, holding status of subordinate execution, and thereafter to amend or to or change, it is required to follow the process of taking decision of board, then sanction of state government, and thereafter to notify in proper notification under section 30. My lord, more specific is there in 35. More specific direction is there, my lord, in 35 point. My lord, kindly see 35.171. Hence, in terms of said General Clause Act of Pension Regulation 2002 has not been amended as yet, following same procedure by which it can frame. More decision of board cannot amend or supersede it. Furthermore, a statutory regulation, namely pension regulation, framed under section 45 of the Road Transport Corporation Act 1950, cannot be superseded or annulled by executive decision of the board after it is duly notified and gazetted. It is a settled law that there is no substantive difference between a rule and a regulation in as much as both are subordinate legislation under powers conferred by the statute. Reliance is made on the constitution bench judgment passed by such and such. It is also a settled legal position that regulations impose obligation on the statutory authorities and they cannot deviate from the condition of service stipulated by the regulation. Reliance is made under judgment such and such. In the angle of those views, the board decision dated 8 April has no effect upon the writ petitioners and other retired employees whose service conditions controlled by the pension division. My lord, on the basis of this judgment findings, the final order issued, and it is affirmed by the division bench and lastly Supreme Court. That means, my lord, we are entitled to get the benefit of the judgment.
Yes.
My lord, then other point, there are other blame. Actually, my lord, what is happened? My lord, if in response to our application, it has been informed in any fashion, you have to submit option, whatever notified. And at that point of time, if I did not submit option, then we believe no such option. My lord. On the other hand, actually, this decision is nullified, had prevented us to exercise option. And thereafter, the decision of the board on 1/10 meeting not to implement the pensions has created the matter very much critical. Thereafter, my lord, even after this, board has itself decided to implement pension as per with other SQs. My lord, kindly see page number 153 and 155. My lord, 153, to consider introduction of pension scheme and SBSTC. The agenda item submitted by MD SBSTC was discussed. So it's not to move government in this regard. Now, the letter of the MD kindly see. 155. 155. To consider introduce pension scheme and SBSTC. This is to inform you that the government employees are covered under, the corporation employees are covered under pendant by linked with provident fund. In the year 2002, a pension scheme was formulated by Transport Department.
There was a resolution to move the government
my lord.
This is only communicating a resolution to move the government,
Yes, my lord.
but not the pension was not adopted. It is only to move the government.
You move the government
Yes.
for approval in the
Yes.
line of the other issues.
Yes.
But if this application was disposed of, then the problem was solved.
But never disposed of.
Till date, not disposed.
All right.
Till date, not.
So therefore, now next point.
This is my lord. There after the order was passed by the in our past case by the single judge, then some events were taking place. That is under supplementary affidavit we have submitted. Board has further decided in 149 meeting. Kindly see supplementary affidavit, page number 12 and 13. Supplementary affidavit.
Page number
12 and 13.
This is the supplementary. Where is the supplementary? Supplementary. Where is supplementary? It's here.
Page number 12. Board sought resolve that pension scheme be introduced in SBTC as per with other schemes in West Bengal. Board authorized manufacturer to move the government accordingly for implementation of pension. Accordingly, MD has written a letter for
Page 12 and 13.
12 resolution and 13 manufacturer letter to government. After the order was passed by the single bench, it is the subsequent decision of the
So still it is the same situation which was prevailing in at page 153. Same situation.
same situation.
No change.
No change. My lord, another important letter is there. Observation report of the MD. It is the
Observation.
report of the managing director.
Huh?
To observation report of the managing director of the corporation to transport department. I will see my lord, page 40. Page 40. Letter is started. I want to cite my lord the concrete proposal of the managing director. Find see my lord, page 17.
Page 40 you said.
That is started.
Yes.
The main points, where the main points I am taking.
What is this?
17.
What is this that you are referring to?
It is on the observation on the pensions, position of the pension of the administration. God can allow me, I can read it from first page. It will be clear. Shall I read, my lord?
No, what is this? Whose case is this?
My lord, he has clarified the position of the pension scheme in administration. And he has clarified it.
Who are the petitioners in that case?
Are covered under, there are now, my lord, discrimination is heightened. The employees joined after December 73 during the period of corporation are getting pension under EPF scheme.
Under?
Employees pension scheme 95 linked with CPF. And
This judgment of 7595 of 2021, you are referring to for what? Who are these people? Who are the writ petitioners?
No, my lord, it is managing director's observation on the decision of the board taken on the
You are referring to page 74.
54. We are appealing 54. Supplementary affidavit.
Yes, supplementary affidavit.
Supplementary page 14.
Page
14, 1, 4.
14.
14. My lord, my tongue is choked for cancer disease.
No, that you have already shown.
No.
That you have already shown. That we have already seen 12, 13, 14. The same situation prevails. Government is being asked to implement.
No, my lord. Here is the main point. My kindly come under page 17.
17.
17. After disposal. 17, second paragraph. My lord, first paragraph. Kindly see. The Transport Department enclosing the letter of the good office of the Honorable Chief Minister. Dated 18th August 2017 and 21st August 2017. And the representation of the SBST of India. Requested SBST by their letter such and such to take necessary action at this end on the considered benefits of the retired employees of SBSTC. SBSTC accordingly sent a detailed report in this regard by the such and such. Then, after disposal of the case by the Honorable Supreme Court, earlier case, my lord, first pension, and in a subsequent state, the SBSTC board in 149 dated 15 February 2018 had further resolved to introduce pension scheme in SBSTC at Paru. The other institutes in West Bengal and necessary approval was solicited by memo number such and such. My lord, in this stage of affair, it feels that decision of the SBSTC board dated 15 February 2018 can be given final after necessary approval and sanction for the Transport Department.
So that is what we are saying. There is no change. Continuously they are writing, but nothing has crystallized.
No, my lord, here is a specific proposal, which is anyway. Here is a specific proposal mentioned here.
Correct. There is proposal after proposal after proposal. But there is no.
Not taken step.
So therefore, we don't have to see every proposal.
No, kindly see, madam.
Please don't repeat the same thing.
No, my said the provision of
We have understood that there is proposal after proposal. There is no final decision. That is an admitted position.
No, here is the second.
They may have said many things that it is desirable, it should be done, but never done.
My lord, the option in case of
whichever officer, it has not been done.
No,
now proceed to the next point. We cannot look into every document just to read the same line in every document.
MD told to get to.
All right, MD has told.
In the line of 60.
All right.
My lord. My lord, the chairman has also written such a letter.
All right, we have understood. Everybody has written.
Yes, madam.
Don't just say the same thing repeatedly.
My lord, the Honorable Division Bench in the second pension case. That is very much relevant for us, my lord. Shall I read out?
Which second case?
49 to 74, my lord. 49 to 74.
No, not 49, 40. It is from 40.
Affidavit, supplementary affidavit.
Yes, it is from 40, I think. 49.
49. Judgment has been stayed by the Honorable Supreme Court.
So if this judgment is stayed by the Supreme Court, why you are reading this judgment?
Now, my lord, it is Supreme Court. They have gone to Supreme Court.
If the judgment is stayed, how we can look into it? We cannot.
Then, my lord, our last submission is this, that we have relied upon the Supreme Court case in our affidavit in reply affidavit. Finally, affidavit in reply to affidavit in opposition. Page number 66. Here the division bench. My lord, actually, corporation deciding to give us, that is not being approved by the government. Government is deciding to give pension at part of the state government. Corporation is not being complied with. My lord, another thing, my lord, firstly, that is kind of see, my lord. What is the government stand? Government stand, my lord. My lord, kindly see affidavit in opposition, page number 27. Page number 27, 27. Oh, yeah, supplementary. This is the government, this is the
Yes,
the
where is it?
supplementary affidavit. In the supplementary affidavit, my
Where is the opposition? Opposition is referring to.
supplementary affidavit.
Huh?
Supplementary affidavit. Supplementary affidavit, page number 27.
You are saying affidavit in opposition.
No, that is go on, let her go. Let her go. Firstly,
The
comment
opposition,
section.
find the opposition. Where is the? Yes.
My lord, it is the letter of transfer from department to the 5 SQs. Subject payment of internal benefit towards.
Again, you are showing a communication.
My lord, it is not communication, direction. It is given under the order of the court.
Maybe, but these are all communications. There is no final decision.
No, my lord, but I have to clear it to the honorable court.
We have understood. We have already said there are repeated communication from both sides, but there is no scheme implemented.
My lord, it is the direction of the government to the
Maybe the direction of the government, but no such provision was in.
But that must have to be complied with, my lord.
All right, so they have not complied.
Yes,
All right. We have
government
understood.
decision is not being complied.
All right.
When corporation is taking decision, government is not according approval.
Now, what is the next point? Come to
Next
the
one
next.
is, my lord, last submission is this. My lord, the Supreme Court case, civil appeal jurisdiction, page number 66, my lord.
Of
Reply to the affidavit of opposition.
yes.
It is the Supreme Court's order.
Page 66.
66 start.
What is this? This is by one of the writ petitioners.
No, my lord, it is our reliance on this.
You are relying on this side.
Yes, reliance on this. My lord, come to the page number 86. Para 20. Page 86, para 20.
Yes.
The antiquated notion of pension being a bounty, a gratuitous payment depending upon the sweet will or grace of the employer, not claimable as a right, and therefore no right to pension can be enforced through court, has been swept under the carpet by the decision of the Constitution Bench in Dokinayan Prasad versus State of Bihar, wherein this court authoritatively ruled that pension is a right and the payment of it does not depend upon the discretion of the government, but is governed by the rules. And as a government servant coming within those rules is entitled to claim pension. It was further held that the grant of pension does not depend upon anyone's discretion. It is only for the purpose of quantifying the amount having regard to service and other allied matters, that it may be necessary for the authority to pass an order to that effect, but to right to receive pension flows to the officer not because of any sort of order, but by virtue of rules. This is my lord, my suggestion is this. We are entitled to pension as per government employees. Corporation taken decision twice to implement the pension as per with the state government. Our service regulation says that we are entitled to wages, DA, etc., as per with state government employees and as per with other institutes. Government decision twice taken, corporation taken twice decision, government is not. Government direction was given that we are giving 100% pension and all the benefits. Corporation is not being complied with. Under this data code, my lord, we are not getting pension, we are on the verge of death. Our submission is this, kindly pass direction.
All right. That's all.
My lord, another, the second pension case, which has been challenged in the Supreme Court, may kindly be read out, my lord. Page 70 or 71. The last second pension case.
Why if that judgment is not applicable today? Why should we look into it?
My submission, my sir, that is on a relevant point is there, my lord.
If that judgment is not applicable today, why we should look into it? Can we rely on that judgment?
No, my lord. We have been referring this last time that we are.
How we can rely on that judgment? You are admitting that it is stayed by the apex court.
No.
It is stayed by the apex court. Where is the question of looking into?
No, my lord, reliance is on this point. On this, our reliance is on this order of the Supreme Court, which is placed last.
That we have seen. Yes. That we have seen.
My lord, now we are praying for justice, my lord, so that we can see.